Okay, so good morning, everyone. Pleasant morning, and welcome to another in our JIPO webinar series. This morning, we're looking at the new design law and the Hague Agreement. Of course, JIPO since April this year has been doing this webinar series to try to share relevant IP information with our stakeholders across the spectrum of IP rights here in Jamaica. So we're very pleased to be joined this morning by a distinguished panel of speakers to share insights and experiences on the new designs law as well as the Hague Agreement, which is, of course, one of the international treaties that we intend to accede to in the very near future for Jamaicans to be able to benefit to register their designs in foreign countries through one procedure, through WIPO, through JIPO. So we're very pleased to have with us this morning Dr. Marsha Cadogan, who is a Jamaican and Canadian IP lawyer from Canaan Consulting in Canada. We also have with us Ms. Teasea Bennett, who is the co-owner of Reve Jewellery and Accessories, who will be sharing on her experience with registering her designs at JIPO. And then we will also hear from Ms. Päivi Lähdesmaäki, Senior Advisor from the Hague Registry of WIPO in Geneva. But first, we're going to introduce Ms. Adrienne Thompson, our JIPO Trademarks, Designs, and Geographical Indications Manager, who will speak on the existing designs law as well as the new law which will soon be in force. So just to introduce Ms. Adrienne Thompson. Ms. Thompson is the Trademarks, Designs, and Geographical Indications Manager at JIPO. Ms. Thompson is an attorney at law with over 14 years experience gained in the fields of IP law and medicinal chemistry research. She was admitted to the Jamaican bar in 2013, is recognized to practice before the US PTO in 2009, and licensed to practice law in Missouri, USA in 2008. She holds a Juris Doctorate from the Tulane University Law School, Louisiana, a Bachelor of Arts in Biochemistry from Vassar College in New York. So Ms. Adrienne Thompson will be our first presenter. As I said, she'll be presenting on the new designs law and the existing law as well. So, Ms. Thompson, over to you.
Okay, good morning, everybody. Let me just share my screen. Okay, so as Dr. Goff said, we're just going to talk about the current design regime in Jamaica and some of the changes that we can expect with the new law. So just quickly about JIPO. JIPO is the statutory body under the Ministry of Industry, Investment and Commerce that has responsibility for the administration of IP laws in Jamaica. It was established in 2001, and JIPO's mandate involves a lot of public education regarding intellectual property, and we also do IP registration for various intellectual property rights, including registration of trademarks, designs, GIs. We also register patents, and we have a voluntary copyright registry. We also do quite a lot of policy development to make sure that Jamaica's IP regime is up to date and consistent with international best practices. Okay, so intellectual property are basically legal rights that accrue to protect creations of the mind. And the designs that we're focusing on today are under the subcategory of industrial property. And the industrial property category also includes things like patents, trademarks, and geographical indications. Okay, so what is a design? So basically a design or an industrial design is the ornamental or aesthetic aspect of an article. So it is the thing that draws your eye to the article usually. So it can be three-dimensional, such as the shape of the article, or it can be two-dimensional, such as a pattern affixed to the article. Industrial designs are used pretty much across industries, so ranging from medical devices to jewelry to phone accessories. You could find industrial designs being used to protect various products. Under the 1937 Designs Act, the design can be applicable by whatever means, such as printing, painting, embroidery, pretty much whatever you can think of. However you want to affix the design, it is protectable under the law. So here we just have some examples of applications of designs. And so shoes is a popular category, furniture, like I mentioned before, jewelry, you have lamps and even chocolates. So a famous example is the Toblerone chocolate bar. The shape of the chocolate bar is actually protected as an industrial design. And so, like I mentioned before, the design is valuable because it is what makes the article attractive. And so, in doing that, it can increase the marketability and value of the product. Okay, so how do you register for a design? Basically, you fill out a form, you tell us what the design is, and how you do that is you're going to submit different views of the design. So 3 different views of the design. You tell us what class of goods the design is going to be applied to, and you pay an application fee. Currently, the application fee is $1,500. And so once you do that, what happens is we'll enter your application in our IPAS or Intellectual Property Administration system, and we'll send you a letter saying, yes, we got your application. We'll then perform a search of the design register to see if there are other designs that are substantially similar to what you're applying to protect. And if it is, then we will send you a refusal saying that the design is refused because it lacks novelty or originality. However, if this is the first time we're seeing this, we'll send you a letter of acceptance and you will get your certificate of registration. And so, like I mentioned earlier, what we examine is whether or not the design is novel. So has it been used in Jamaica before? Is it original? Is it different from everything that already exists? Or is it just a copy of a previous work? And we also check to see if the design is scandalous. So assuming that you pass all the hurdles for registration, like I said, you'll get a certificate of registration that's valid for 15 years from the date of your application. And design rights, like many other IP rights, are territorial. And so registration of your design only gives you protection within the boundaries of Jamaica. If you're interested in getting design protection in another jurisdiction, then currently what you have to do is you have to essentially register the design in that jurisdiction, and usually that involves retaining foreign counsel to submit your application. However, with the new law that's coming, there will be a repeal and replacement of the 1937 Design Act, and it will bring our law into the modern framework that is consistent with other design laws around the world. And one of the features of the new law is that it will allow us to join the Hague system. And Päivi will talk more about the Hague system, but basically it will make the process of obtaining design protection in forest jurisdiction easier. Okay, so under the new law, some of the changes involve updating the definition of design. So on the slide, you see the old definition under the 1937 Act. The new definition is basically just using more modern language. And so a design is any composition of lines or colors or any three-dimensional form, whether or not associated with lines or colors, which gives a special appearance to the product of industry or handicraft and serves as a pattern for a product of industry or handicraft. In addition to updating the definition, the new law has adjusted the things that the registrar will look for when we're examining your application. So the criteria for registration has also changed. So the new criteria is that the design has to be new, it has to have individual character, and it can't be contrary to public order or morality. So novelty or newness. Basically, before the filing date or priority date of the design, we will examine the application to see if the design has not been made available to the public anywhere or at any time. So under the 1937 Act, while we will examine for local novelty, in the new regime, we're going to be examining for worldwide novelty. Under the new law, there's also a feature where if your design has been disclosed, either due to unlawful disclosure, breach of confidence, or if you display the design at a local, regional, or international exhibition, as long as that disclosure occurs within 12 months before you file your application, there's essentially a grace period. And so you won't be barred from filing the design as long as it's within 12 months of that disclosure. So individual character is a new feature of the law. And so under the law, it's described as if the overall impression it produces on the informed user differs from the overall impression produced by any earlier design already made available to the public. So what that means is your design can essentially be unoriginal. It cannot be a copy of something that already exists. And so in the pictures below, the design on the left, that application or design, it was actually invalidated based on the door handles on the right. And so what the court found is that even though the design passed the novelty bar because it had some grooves that made it new or different from the earlier design, the impression to the informed user is pretty much identical to the earlier design. And so it didn't pass the individual character bar. So we'll be looking for things like that under the new law. We'll also be looking to make sure that it's not contrary to public order or morality. So this is basically the updated version of the scandalous provision under the 1937 Act. And so basically what that means is the design can incite violence, it can be sexually explicit or offensive to a section of the population. In addition to examining for those three criteria, the law also goes through some bars to registration for designs. And so I have a list here that summarizes some of them. So what we'll be looking for, if your design contains a national emblem or symbol of Jamaica, you need to submit the consent of the government of Jamaica. You need to submit proof of consent to the registrar. And so for national emblems and symbols, you obtain permission from the Office of the Prime Minister. Similarly, if you're using the country name, map, or colors of Jamaica, you have to show us that the design isn't misleading and essentially creating a false connection with Jamaica. So you might have to submit proof to the registrar that your design actually originates in Jamaica. Similarly, we'll use our same standard for national emblems for the emblems and symbols of other countries, and also the names of other countries. So what we'll look for is whether or not the design is misleading and whether or not you have permission from the owners of the national emblems to use these, for example, the coat of arms or their flags. Similarly, the emblems and abbreviations of international organizations will also have to have consent. So, for example, for the International Olympics Committee, you have to get permission to use the Olympics rings. So you can't just use the Olympics rings because the Olympics are coming up and you think that this will help you to sell your product. You actually have to get permission. And we will ask you for that if it's in your design. Also, if your design features any registered or unregistered trademarks, the registrar will ask you if you have the permission of the trademark owner to use their design. And so we won't register the design unless you submit proof of consent to use these works. Similarly, if your design contains a copyrighted work or somebody's likeness or image, you have to submit to us that you have the consent of these individuals to use their image or to use their copyrighted work. And finally, if your design contains the traditional knowledge or traditional cultural expression of an indigenous or local community, then we will ask you again if you have consent or authorization from that indigenous or local community. And so this often arises in the context of the Maroon community and the Rastafari community, where people will use a lot of their symbols in their designs. And so you need to show us again that you have their consent. Okay, so some other features of the new regime is that the design protection will not be applicable to anything that is functional in an article. And so, like I said before, the design is applicable to things that are ornamental or aesthetic. But once it crosses over into a functional aspect of the article, then it won't be eligible for design protection. And so if you're submitting something that has functional elements and the ornamental elements, then you're going to have to point out to the office what is the functional part of the article and what is the ornamental part so that you will get protection for just the ornamental part of the article. The new law also allows for priority claims. And so once your design application was filed within 12 months after the filing of the application in an overseas country that is a party to the Paris Convention or to the World Trade Organization, then you can essentially obtain the filing date of the earlier application by claiming priority to that earlier application. But again, the later application has to be filed within 12 months of the earlier application. The new law also features a new classification system. So under the 1937 Act, we're using 12 classes for classifying goods. Under the Locarno classification, which is an international classification system, you have up to 32 classes, so you can be more specific in how you classify your designs. And also, it will help to standardize how your goods or services are categorized across the world. And so, if you're then going to be using that application and going to another jurisdiction, you don't have to reclassify it because we're using a local classification system. Because we're using Locarno, it's easy to move from one jurisdiction to another because most jurisdictions use Locarno. So under the 1937 Act, one application gives you registration for a period of 15 years. However, under the new act, registration is for 5 years, but you have the option to renew the design twice consecutively. So you still get back to the 15 years. It's just that you'll have to renew every 5 years if you intend to continue to use the design. Another feature of the new law is that applicants can defer publication of their designs. You just have to put that in your application. And so under the new law, once you submit your application, we examine it to see whether or not it's registrable. If we accept your application for registration, then we're going to publish the design in the IP journal. And so what that does is it will allow for an opposition to the design, so the public can say, I oppose the registration of the design for some reason under the law. And so the opposition period is for 2 months. The new law also allows for revocation of registered designs. So for example, if somebody missed the opposition period and the design proceeded to registration, but they really believe that they have a design that would be a bar to the registration of the design, then they can apply to the registrar to revoke the design because, for example, it's not novel because their design is pretty much identical and their design is earlier in time. Under the new law, the public can also search and inspect the register, and anybody can apply to rectify the register. The new law also establishes new offenses, so including falsification of the register and false claim regarding registered designs. So we don't have those under the 1937 Act. And so, like I said before, what design registration gives you under the new regime and under the old law is you have the exclusive right to exploit your design in Jamaica. And so if anybody else is trying to use your design, you have to give them, as the design owner, authorization. And so listed here are some of the rights of owners. So you have the exclusive right to make, sell, import, or otherwise distribute the design for commercial purposes. Some of the exceptions to those rights is if somebody is using the design in a non-commercial private way, then that would not necessarily be an infringement of the rights of the owner. Also, if somebody is using the design for purely experimental purposes, or they're reproducing the design for teaching purposes, and they expressly state that, you know, they're using the design for the purpose of teaching and they cite who the owner of the design is, then that is also not an infringement of the design. The new law also features provisions relating to employer and employee rights. So typically, the person who creates the design, the creator of the design, is the owner of design. However, if somebody commissions the work, if somebody commissions that the design be created, then the person commissioning the design is the first owner of the design. If the design is created in the course of employment, then the design belongs to the employer. Also, if the employee creates the design on their own time and they're not using work resources, then in that case, the employee is the owner of the design. However, if the employee uses information or means of the employer, so any work resources that the employee uses to create the design, then that could create a claim that the employer is actually the owner of the design. The law also allows for recognition of employees' rights and allows for compensation of the employee, which is not featured under the 1937 Act. Okay, so So the new cost to register is outlined in this slide. And so now to register a design in one class from start to finish will cost 14,500. And so that's broken down into the application fee of 7,500. And then once the design is accepted, you're going to pay 3,500 to publish the design, an additional 3,500 for the registration of the design. If you intend to register your design in more than one class, then there is an additional class fee of 2,200 per class. Okay, so that's the new law in a nutshell.
Thank you very much. So we're going into our next presentation. I want to thank Ms. Thompson for that presentation. Very thorough, the current legal framework for the design. We've had for some time. And now we are preparing to move boldly into the 21st century, the new designs framework. And so, thanks again, Ms. Thompson, for sharing that perspective and those insights on what we can look forward to in the new designs law. I do see some questions, so I'm going to just ask if we can hold those questions until the end. We will be having a Q&A segment where we can have questions for all presenters posed. So just stay with us. We will have the Q&A shortly. And I'm going to introduce our next speaker, who is Ms. Teasea Bennett. Ms. Bennett is a co-owner of Reve Jewellery and Accessories. She holds a Bachelor's of Science degree in tourism and a minor in French from the University of Technology and the University of the West Indies. After living and working in New York, London, and France, she, with her brother Dwayne, established and co-founded Reve Jewellery and Accessories in 2006 in Kingston, Jamaica. The sibling entrepreneurs then opened their first all-handmade showroom in 2009 in Devon House, which also retails our local and regional producers. The company has garnered several international awards, and their bold designs can be found among the collections of many beloved celebrities, including Kelly Rowland and Shireen Anderson. Currently, Teasea serves in local and regional organizations, including the Association of Caribbean States, where she is a representative for women in the creative industries. She also is a part of WENC, Women Entrepreneurs Network of the Caribbean, and recently she was made a brand ambassador for the Organization of Eastern Caribbean States. She balances her roles of mother and wife as well as acting CEO to her company, which as we said is based in Devon House, Jamaica. So very pleased to have with us in the webinar this morning is Teasea Bennett to share on her experiences with the designs law and design registration for Reve Jewellery. Good morning, Teasea.
Hi, good morning again, Marcus, and good morning to everyone who is here. I am very happy to be here to share my experience with the JIPO and most importantly, the importance of protecting our creativity as a Jamaican creative entrepreneur myself. So thank you for that. Before I go into my presentation, I wanted to say that JIPO, I didn't even know JIPO started in 2001. So I want to thank the previous regional manager from JIPO to come in and educate me. That was really informative. I love learning, and that was some great information. Now, my passion and why I'm here is to share the importance of protecting our intangible asset. It's the greatest thing we have as a creative entrepreneur. And I'm so passionate about it that I've had the opportunity to share with other organizations with more training regarding intellectual property. And I like to be colorful, and I'm just going to just speak from the heart. And so my designs that I wear really started out with my brother's creativity and what he produced. And he, in our company, is a creative genius. He's a goldsmith, which is a technical term they use for fine jewelry maker. But what really makes Reve Jewellery so different is that not only did we were successful in getting our trademark for the logo, the Reve brand here with JIPO, to distinguish Dwayne's work. What we've really done when we started in 2006 was not only was my brother making pieces using fine, the traditional fine jewelry resources such as gold and silver, diamonds, and all the precious or semi-precious stones. We also incorporate elements from the Jamaican environment. We're very much inspired by our culture, by our people, by our food, by the heritage of Jamaica, and our pieces are a fusion of that. And so we also incorporate non-precious and natural resources when we make our pieces. It so happened that we were on the cusp of something very unique and very special. And because we're not fine jewelry, we're not cosmetic or fashion jewelry, and we're definitely not craft jewelry. So what we found is that we became a novel item. And I heard that word being used before. That's a very important word when you're looking to get intellectual protection, IP protection. And those are some of the things and the criteria that is important when you're looking to register your IP. I just wanted to use a layman terms for me, to speaking again from the heart. So a trademark is simply a mark, could be a short phrase or a name, which identifies the source. So in my capacity in our company, as acting CEO now, I'm also charged with marketing, public relations, and sales. And of course, from the marketing perspective, it's very critical to build solid relationships with your customers, what they're consuming, what it is that they like about your product. They do help to define your product as much as looking at the competition. And so for us,
Sorry, Teasea,
yes.
not to break you. I know you have some slides. I don't know if you wanted to share them or you want us to share them for you, or you're okay.
I'm going to share them. I'm going to share them after this. I just want to
Okay.
establish that. Mhm.
All right.
And so for us, when we got our trademark, it really helps with identifying and making the mark in the market, in the marketplace, because our legacy is to become a global brand known from the Caribbean. So I know Marcus is anxious to get into my slides. I'm glad to see that. I'm going to share that shortly. But I just wanted to explain why it was important for us to go ahead and get our trademark. The best advice a mentor gave me when we just started in 2006 was, do not expose your creativity until you get protection. It was the most valuable, solid advice I've ever gotten. And I'm always happy to share that with existing and upcoming creatives and entrepreneurs. You can establish your trademark, your patent, your logo, whatever it is, before you do your business. Very critical. So now I'm just going to go into the slide and just give you a little background on who we are as a company and some of the items that we protected, because we've done a few. Please let me know if you're seeing the screen.
No, we're not seeing it. I think you had it a while ago, but it went down. You just share again, please.
I'm sorry, you're not seeing it?
No.
Okay, let me go back.
Yes, it's coming up now.
You seeing it now?
Yes, we're seeing it now.
Okay. So let me just bring this thing back here, and icon is blocking my thing. I'm trying to show.
Apologies. There's a word besides stop sharing. It's called hide.
It stopped sharing again?
There's a word beside called.
Okay, let me.
This
Let me go back.
Besides stop sharing. It's called hide. If you press it, it hides that pop up.
Are you seeing it now? Well, I do hope you got an opportunity to see that.
Yes, we saw.
Okay, great. All right, so now I'm going to go into the other slide, which is going to be sharing just a little background of who we are. So this is my brother, who is my business partner, and he's the goldsmith I talked about. So some of the pieces that, some of the awards that he has won has included the Red Bull Art of Can, Avant-Garde Designer, Vanguard Award, and so on and so forth. And of course, in my intro, Marcus did talk about some of the people who worn our stuff. And because of his work, we've been invited to participate in many different trade shows and fashion events in the region and internationally, including not only locally, which is Jamaica Style Week and Jamaican Fashion Week, but also London Fashion Week, Dominica, Republic Moda Fashion Week, St. Vincent, so on and so forth. And we've gotten the wonderful opportunity of being featured in several major regional, local, and international media, including American Next Top Model, US, Caribbean, and British Next Top Model. And of course, I'm just showing an intro of who we are, which was mentioned before, so I don't need to go into that. But most importantly, I want to talk about some of the pieces that we have protected. On the right, you will see a model wearing a very colorful piece. All these designs were made by incorporating things like this project. We did it to show that you can actually upcycle and recycle and reuse things like plastic and elements from basically from our environment and things that pollute the natural environment and turn it into something very fashionable. So it's all hand woven pieces using plastic cups and wires and things like that. And this piece was featured on the cover of the local directory, global directory. And I wanted to bring this up because I remember when we did the photo shoot and everything, it was just mentioned about things that are exempted. So this was done as an IP for Yellow Pages for their cover and all of that. Yet we had to ensure that we got permission to go ahead and use this photo internally for promotional purposes. So it's a part of our marketing packaging. When you go online to revjewellery.com and you order something, you will get like a thank you card and so on. And sometimes we use images that has been used in a campaign for another company and so on. But because it is not being used to make money, but more to share what is going on and to share the whole creativity and the whole fashion aspect of it, it's perfectly fine to use these images and these items. On the left, you will see a model wearing our beloved Ali cuffs. And not only did we get the trademark for our logo, but we also have what we call an industrial design, which is one way that you can also, how would you say, level up protecting your designs, protecting your intangible assets. And so these bracelets are such a top seller and it's such a distinctive look for Rev Jewellery. They're called the alley cuffs. We do them in, the model here is wearing it in brass, which is a non-precious metal, which doesn't change, but we do it in gold and silver. And because of this, we ensure that we got additional protection for this design. So literally we're the only ones who are allowed to manufacture this design. I will move on to some more designs that we have, and this includes our beloved rings. We have a few rings and some poppy design using special techniques to bring out certain reactions from the metals. And it gives a beautiful color that we actually, they're like literally wearable art, because of course it's handmade, no two things are the same. And when my brother and his team does the work on the items, he doesn't have any control of how the colors come out. And so the model is wearing some pieces that, again, we have our industrial design trademarks done. Another category of designs that we have are our sandals. Sandals are a big thing in the Caribbean, big thing in Jamaica, and we wanted to be a part of that market because me personally, I love wearing sandals. Usually 95% I'm wearing sandals. And so we decided that we wanted to do what we do best, which is to be innovative, to be creative, and to be different. And what sets our sandals apart is that they incorporate a novel design. They incorporate using jewelry techniques. And we have about 6 different categories, and all of them, I made sure to get them covered with JIPO. And as I said, I'm a strong, like passionate, like free campaigner talking about I cannot talk about the importance of this enough. If we look at companies out of Europe, like the Louis Vuittons and the Coco Chanels and the Hermes, who have been around from the 18th, 19th century, they have been instrumental at protecting their most valuable assets, which is the intangibles, they're creative. And of course, I'm happy to see that Jamaicans and just regionally, this is really becoming a more mainstream conversation because it is really how a creative person is going to ensure their legacy and they make money and they can make just a better way of living for all their stakeholders and everything that they touch and everyone that they're involved with. And so our sandals is just an extension of how we feel about that. And I will even go as far as to talk about other local sandals producer. I remember going to an event in the UK, and we were in London doing a special reception cocktail party at the High Commission, Jamaican High Commission. And there were persons from other High Commissions, and they were like, "Oh my God, do you have Bridget sandals?" And it just warmed my heart to hear other people recognizing, persons who are not Jamaican, recognizing a Jamaican brand. And she's a wonderful brand who has also, I'm sure, has her ideas and her designs registered with JIPO and other agencies. So if you want to reach out more and be in contact with us, you can find us at Devon House. We've been there since 2009. We're still there if you've got fans, despite the COVID. And we have restricted hours now, so we're primarily closed on weekends, but we're there weekdays. And you can find us on social media platform at Reve Jewellery, which is REVE. And we do a slew of services, anything that it's regarding jewelry and accessories. And we also will be happy to talk more to other creative entrepreneurs about connecting with strategic partners such as JIPO and learning more. But that's it pretty much. I want to thank you all again. And yes, if you have any questions, just please send them and we'll try our best to address that. Thank you.
Thanks so much, Teasea, for this. For that interesting sharing of the journey with us. You and Dwayne and how the business has grown, and of course how you use IP rights to expand and to protect your innovations. So thanks for that interesting and very vivid presentation. I know you got some questions when we reach the Q&A for sure. All right, so I'm going to progress with introducing our next speaker, Dr. Marsha Cadogan. Dr. Marsha Simone Cadogan works in the areas of international intellectual property law, trade and technology licensing. She's a practicing lawyer of the Ontario Bar in Canada and has a PhD focused on intellectual property rights and development. She's the primary consultant of Canaan Bridges Consulting and the principal of MSc Intellectual Property and Technology Law. Her expertise is in most areas of IP, strategies to mobilize IP into strong assets in developing and developed countries, and the IP intersections of blockchain and distributed ledger technology. She authored various peer-reviewed publications and journals and business magazines and different aspects of IP strategies, including on Jamaica and the Caribbean's IP narrative. She is the Canadian representative to the International Association for the Protection of Intellectual Property, Geographical Indications Standing Committee, a member of the International Association for the Advancement of Teaching and Research in IP, AGIP, and a board member to the International Law Association Canadian chapter. She's also the chair of the Licensing Executive Society for USA and Canada, Technology Startups Subcommittee, and is a Canadian expert in the Standards Council of Canada and ISO on blockchain and distributed ledger technology. Very pleased then to have with us also this morning Dr. Marsha Cadogan, who will present some case studies on how to further and leverage your design rights through IP strategies. Thanks again, Dr. Cadogan. Welcome.
Thanks, Dr. Goffe. It's good to be here. Can everyone hear me?
Yes, very loud.
Okay, great. Can you see my screen?
Yes, we're seeing you and we're seeing your slides.
Awesome. That's great. Okay, so it's really great to be here. Thank you, Dr. Goffe, and everyone else for inviting me to talk about something that is really relevant to having a effective and strategic IP strategy, a firm level IP strategy, broadening your IP portfolio, including design rights as an aspect of that. So Dr. Goffe invited me here to talk about that, and I'll talk about it from the perspective of law, but also from a practical perspective in terms of how you can use this to leverage your IP, not only in Jamaica or the Caribbean, but also internationally, which is where I believe that we all need to move towards if we're really serious about having benefiting from intellectual property. Okay, you should not be seeing that. All right, so my roadmap for today, and I'm hoping that I don't go over 20 minutes. Sometimes I do kind of talk a lot. I'll talk a little bit about firm level IP strategy, because it's never sufficient to just register your design right. It needs to be a part of a full scale approach and outlook to how you're going to benefit and perhaps collaborate with others towards the long-term success of your business. Then I'll talk about issues at the domestic. I need to maximize my slides. Okay, I got your. Okay, are we good now? Yes? No? Okay. Then I'll talk about how design rights fits within the IP system, and that is more really a comparative look at where, if you think about design rights to trademarks to copyright, is there a difference? Is there an overlap? Then a little bit about domestic and global issues in terms of if you're leveraging design rights. And also then I'll talk about innovation and commercialization, the big picture from a case study perspective, and then going into the intricacies of case law. What is case law saying about this? How does this impact you as a business person, as Ms. Bennett, or even if you're in a university and you're interested in doing some form of invention that has a design right perspective to it. Finally, I'll talk about, so the conclusion going forward, what should you bear in mind? And because I'm also into licensing, when I talk about commercialization, I'll talk a bit about tips in licensing your design rights as well. Okay, so it's always good. It's to have a firm level intellectual property strategy. The word firm there is included because there is a difference between having a firm approach, a firm level approach to IP from a national approach. A national approach, you're looking at how the government approaches intellectual property in terms of the laws that are implemented, and also in terms of it could be monetary or fiscal incentives that they use to leverage or position IP towards success. The firm level IP strategy, if you use one, it can either lead to your IP being strong or weak. So it's best to, you're thinking of your business strategy. Then a part of that mix is how you approach developing and maintaining IP. Also, and that is the creation of IP itself, and also how you commercialize IP. Now, all these measures, so it's really about the policies and the measures that you put in place to greater ensure, you can never guarantee because, like COVID-19 was unexpected. So that's an external issue that may impact the success of your intellectual property business. But on a whole, how you approach this from a firm or business perspective will determine if your IP is strong or if your IP is weak. And then we move on to we'll get back to the first slide in a few minutes, but let's discuss a little bit what is the difference really. Is there a difference between design rights and any other right? And Ms. Thompson did a really great job of explaining what the new design law will be about. That was really excellent. So and when she discussed it, she also mentioned issues about trademarks and copyrights, and also about scandalous names and what cannot be registered, but we can discuss that later. If you compare a trademark to design, right, or trademark really focuses on it's identifying, it's a source identifier. So it's identifying the source of the product or service. And globally, it's used extensively. It's probably one of the most well-known types of intellectual property. Copyright focuses on the creator or the performer's work, and it's widely used. Probably the most commonly used form, whether mostly on a sometimes registered, but much of it is also unregistered. Patents now focus on a process or a method involved in creating an invention. It covers the more functional nature of your invention, and it's again widely used, not as much as is trademark, as our trademarks are copyrights, but it's probably the most valuable form of IP, can be, if it's commercialized properly. Now, design rights, as Ms. Bennett spoke about earlier, you're talking all about the visual representation of your product. So think about it this way. It's the visual appeal of your product, and it's being protected in an intangible way by this right. Ms. Pavi will talk about this, I'm sure, much more in terms of the Global Innovation Index that was recently published by WIPO along with Cornell University, that talks about the level of innovation by different countries. You'll find out that industrial designs or design rights, it's not used consistently or extensively in every jurisdiction, but when it is used effectively, when people use it on a very innovative level, you find out that it brings much success, as has been proven in Sweden, in Japan, it's in Switzerland, and even in the US. By the way, can you see am I showing on camera or is it just my screen? Okay. All right, so let's talk about leveraging design rights in global economies. So I'm an international IP lawyer. I don't just look at what is going on. I don't just focus on leveraging or monetizing IP in domestic jurisdictions. So not just Jamaica, the Caribbean, or Canada, but how can you take it globally and how can it be sustained globally? Two things or two dynamics here are important. The first is think about innovation and commercialization. Very important. The second one is what type of strategies can you use to manage your design rights? And I'll go into this a bit more in the latter part of the discussion. Going back to the conversation about the Innovation Index for this year, Jamaica did really well, I think, coming in at number 72. And I believe there were over either 170 countries or over 150. At the same time, design rights, it's not being used extensively there, but it's not being used extensively in Canada either. If you look at this current slide for the year 2018, you'll see that in terms of residential filing of design rights, there were only 769 applications for 2018. And people and firms or individuals filing industrial design applications coming into Canada, so non-residents, was over 7,000 applicants. That's a huge gap right there. And I'm actually writing an article about that that Canada is not doing very well in this regard. Hopefully this will improve in years to come. The only reason why I've included this slide is to show that even a developed country is not, not because a country has a status as developed, it doesn't mean that they're doing well and are very, effective at fostering all types of IP, including design rights. Now let's go back to innovation and commercialization. There are many types of design out there, and we can talk about this later, but I believe that going forward, we need to be innovative in our approaches to what we design and how we commercialize it. And it's best to build, and Ms. Bennett spoke about this before as well, build collaborations or connections with different sectors or industries, whether this be locally, regionally, or internationally. If you're new to design rights as well, or new to IP, think about, and you're based on the discussion before by Ms. Thompson and Ms. Bennett, if this is an area that you're interested in, think long term, think about more non-traditional sectors or industries. How can your design concept and the expression of it make a difference in the high technology space, such as in medical devices? Here we think about COVID-19, in the automotive sector, or high consumer demand space, such as Ms. Bennett's field, fashion and contemporary furniture. The benefits of doing this, and I could go back to the slide that I started out with initially, but kind of have that somewhat in your mind. It goes back to that IP strategy that we spoke about before, where you want to ensure that you're being innovative in your approaches, that you're building collaborations for one, and that your design, as is depicted on the product, is visually appealing and is in demand by consumers. Now let's get into case studies here in terms of the creation and development of the design. Here we're thinking about being innovative. And, when I talk about IP, I always talk about IP in regards to sustainable development goals, such as, innovation, building infrastructure, creating jobs, helping out women-led businesses. And so if you're new to this field or thinking, how can I register a product with JIPO and other IP offices as well using the Hague, think about, for example, green technologies. On the right of your screen, there are two diagrams there, and these are registered designs from the WIPO Global Design Database. The first is a power washer, and again, it covers the shape of the power washer. The second is more environmentally focused. Now we're thinking about green technologies, and it's a hydrogen and oxygen electrolytic generator. And again, it covers the shape of the design itself. But now, think not only of making ensuring that it's relevant in terms of development goals or innovation goals, or what, for example, a venture capitalist or someone who's willing to give you funding may be interested in financing, but it also needs to have consumer appeal. Now, the products on your right shows a car. It's from China and it's protected by a registered design. Also, the middle diagram shows a water bottle, and this is out of Finland. The bicycle is an electrical bicycle. This is out of China. That's a Nike sneaker. Again, it covers the shape or the features of the sneaker, and then the other design shows another car out of China, again covering the shape of the vehicle. So now you can think of not only in terms of regular consumer items, but also other types of products that your design may be applicable to in terms of registrability. Challenges before and after registration. I'm hoping that I'm not talking too fast. Let me know if I'm talking too fast. Now, Ms. Thompson covered this before. Disclosure is so important. She mentioned that if you've disclosed your design within 1 year, 1 year before you filed it, then you're still, it doesn't affect the novelty of the design. What if you've disclosed your design outside of that period? Obviously, it affects the registrability of the design. Points to be careful here of, okay, so you've come up with this really great product, and you've lacked the funding to perhaps to produce it on a critical mass level, or to actually bring it to market. Be careful if you're doing crowdfunding. So if you're interested in Kickstarter or so on, and you disclose that design outside of the grace period, you will be affected. Same thing for trade shows. If it's outside of the grace period, you more than likely will be affected. The other thing is that different jurisdictions may have different grace periods. Under the Hague agreement, it's 6 to 12 months. So you may find that some jurisdictions, the grace period that you're given is 6 months. And so if you've disclosed your design, say at month 8, and you've applied for a design in China, then you're not going to get it. So you got to be careful. So it's good to have, again, going back to that firm level IP strategy, know your markets, know which jurisdiction you'd like to target, and work on it from there. Now, as Dr. Goff said before, let's talk about practical issues now that we can relate to, that may impact or can impact how we approach registration or an application for a design right. Let's look at Jaguar Range Rover. Okay, so I have about 3 cases to discuss. So this is the first one. So what happened was, this happened in China. Jaguar sued a Chinese manufacturer of a Landwind X7 vehicle for infringement of their design right, on the basis that it looked very similar to their own. Therefore, they're saying that it lacked novelty and it's not distinct. So this great company sued this Chinese manufacturer, and they thought they would have won. And the dispute went on for about 3 years, going back and forth. But guess what? It ended up with Jaguar losing their design right and also the Chinese company Landwind X7 also losing their design right. What happened was when Jaguar sued the Jiangling Motor Holdings, Jiangling Motor Holdings also countersued Jaguar to say, you know what, your design is not novel because you displayed your car at a trade show a year before you submitted your application for the design in China. Now, Jaguar had submitted the design, Jaguar had showed the vehicle at this provincial trade show in China in 2010, like December 2010, and then applied to register the design late the following year. So now we're looking at November 2011. Now, bear in mind, if you remember that I said in China, the grace period for disclosure is 6 months. In China also, their IP office only in terms of design rights anyway, it's not a substantive examination that is carried out for design rights. So it can be relatively easy, but do your own research because it may be different depending on the type of product that you're registering. So it's not a significant hurdle to obtain a design right in China, but it can be a significant hurdle to overcome infringement of a design in China. However, the latter point did not work against Jaguar in the end. So Jaguar's design right was invalidated, but also Landwind's design right for the vehicle was also invalidated on the ground that the designs were very similar, and Jaguar submitted proof to the court to say that we have receipts and advertisements to show that you have been advertising the vehicle and selling the vehicle, and it's very much similar to our own, meaning Jaguar's vehicle. So in the end, they both lost the right, but that was not the complete ending. Jaguar had another tactic up their sleeve. They used unfair competition grounds to argue that what Jiangling Motor Holdings was doing was unfair. Their brand is well known worldwide and in China, and that Landwind is trying to benefit or free ride on their reputation and their goodwill in the market. Also saying that customers are being misled by both vehicles being in the same market, meaning in China, luxury vehicle. And so they won on that ground. And this was in 2019. So that was finally settled. Point of this conversation is trade shows. Be careful about your disclosures and find out basic information depending on which market with jurisdiction you're registering your design in, what their disclosure situation is like. Now, the other point is prior art searches. Prior art searches covers, okay, you've designed this great thing, but in terms of strategy, it's best to say, for example, if you want to design a Rubik's Cube, don't do it, by the way, and I'll tell you why after. If you were thinking of designing a Rubik's Cube, do a search. Go on the internet, and there are various databases that you can use and find out if there are any other similar design either to the Rubik's Cube or anything else that would impact the registration of your design. So in prior art, you're trying to find out, is there anything similar out there? And the more global your approach is to the commercialization of your product, the more global should be your search. Now, in the first case, and this refers to these two diagrams here, This case was between Rubik's Cube. We're probably all familiar with Rubik's Cube. I remember playing with Rubik's Cube when I was a child. And so because they're very well known and they applied to the EU IPO office, the invalidity division, to invalidate design right. Okay, so that's moving too far ahead. 1 second. Okay. There we go. Okay. Okay. To invalidate the design of the diagram of this play toy, they call it. You've probably seen this before. So it's a Taiwanese manufacturer and it's a registered design, was a registered design in the EU, and the cubes are joined together and they're play toy. They're marketed under the name of the play toy for kids or children. So Rubik's Cube sought to invalidate the design right of the Taiwanese company on the basis that, your design looks very similar to our own. Now, in this discussion, bear in mind that this diagram here, it's actually not a design. It's a trademark, or it was a trademark. But as long, the approach used by Rubik's Brand Limited is that we're in the same market as you are. We're both in the toy market. Your design is similar to our trademark, and so it needs to be invalidated because we've been around longer than you and it's prior art. And the IP invalidity division agreed with them, and so the Taiwanese company lost the right to use this design, and this happened last year. But on a side note, bear in mind, Rubik's Cube also lost the right to use this as a trademark. So if you were to do a search for this trademark now in the EU office, it's no longer there. But that's a side note. Point of this is do your prior art searches. Now let's talk about another example, which is kind of ended up a bit different. So, and this pertains to the slipper on your right, kind of far right of the screen. You've probably seen the slipper before. It was a dispute between Puma, Fenty, Rihanna Design, and Forever 21, where Puma sued Forever 21 to say, what, they're actually the Puma design is a registered design in the US, and Puma said that your design looks very much similar than ours, and you're trying to free ride off the reputation that we've built up in the market, in the shoe industry for so many years. And this went on for a little while, and the court agreed with Puma Fenty design to say, they're pretty much the same. The shapes are very much the same. There's no substantial difference between them. This would be Puma, and this would be Forever 21's design. And the court held that there was various different motions, and one of the motion was that this design is invalid, and Forever 21 should stop using the design. But then Forever 21 said, your design is not novel because this design has been around since 1952. And it was not only specific to these slippers, but there were also some sneakers there called creeper sneaker. And the case was settled out of court. Puma and Forever 21 came up with some settlement agreement. So this goes to show, again, it's the leveraging, the power, the bargaining power of both parties. These are both well-known chains, consumer products in the market, they have the ability to bargain greater than would be, a little person who's just trying out. They're a little mom and pop establishment, for example. The other, so this is the EU, this is US, and then the final case that, I want to talk about is a case in Canada. You've probably heard of Budum. They make kitchenwares and glass, drinking glasses and all kinds of stuff. And their design is this one. And then the other design is here. And because it's actually a company, its main office is in Switzerland, and they license their rights to a US company, and the US company distributed the products here in Canada, and they sued Trudeau Corporation to say, that your glasses look very much like ours and you're infringing on our design right. And it went if you read the case, it's over like 103 paragraphs, but at the end of it, the court decided that these glasses here, so Budum's glasses, were actually around since 1897. So it was prior art. There's absolutely nothing novel about it. And this was the claim that Trudeau Corporation was making anyway, that your design is not novel, it's been around for a long time. And so the court sided with them on the basis that it's been around since 1897. And then the other point is they even disclosed the design in 2003 and registered it outside of the grace period. So there were two factors there that were working against Budum. Point of this conversation, do your prior art search.
All right. Thanks, Marsha. Can I ask you just to wrap up in probably 3 minutes?
Yes, sorry. Okay, I'm almost finished. Licensing, we can talk about this as well during, the question and answer period. If you're licensing your design, be careful, just ensure that the licensees and also the sub-licensees are using the design in the way they should. In some jurisdictions, you will need to use the D sign and the circle followed by the abbreviation and or the name of the proprietor of the design. In other jurisdictions, it's not required. If your market is in Canada and you are you've licensed your right here, then, and there is an infringement of your design, if the mark D followed by the circle and the name of the proprietor is not on the packaging of the product or the product itself, the only remedy available to you is injunction. Injunction meaning you can stop the person from making or manufacturing the product, but you're not going to get the remedy of an accounting of profits or damages in terms of a monetary figure. You won't get that. So, it's always good to ensure that you use that mark. Also be careful that the design that you've registered is what you're using on, in making the product. And I can give you another example, but I don't have time to go into it. Also, what if you've licensed your design in Jamaica, Barbados, and other countries, and it gets invalidated in Canada, and then it gets invalidated in one of these countries, and there is a licensing agreement. Ensure that these issues are covered. Point also, in terms of when to license your design, don't do it too early to prevent there being substantial variations between what you've registered and what you end up using. And also don't do it too late so you fall outside of the grace period. Things to note, this is like, hopefully I can do this in about 30 seconds. Think globally in terms of a strategy. The relevance of your product in terms of the demand of your product and the connections that it can make is just as important as the right itself. The but does not stop at your registration. You may register a design, but if it's not being monetized effectively, then it's of no use to you, really. And then also effectively manage your design. Thank you. I'll stop there for now.
Thanks so much, Marsha. Thanks for that. Yes, I can see the lecture new coming out there, you know. Okay. So we appreciate it and know that you have a lot more to share with us. So hopefully we'll have some good Q&A again where we can interrogate some of what your slides were showing us. So now we're going to invite our distinguished speaker from WIPO, Ms. Päivi Lähdesmaäki, who was here with us in March this year before the lockdowns. Ms. Lähdesmaäki has been working at WIPO since 1998, dealing with trademarks, industrial designs, geographical indications, and the Madrid, Hague, and Lisbon system for international registration of sale. Since 2009, she's been working in the Hague Registry for the brands and design sector of WIPO. First as head of the legal section, which was also had her as the secretary for the working group on the legal development of the Hague system, and then as head of the development and promotion section. In her current post, she's the senior advisor in the Hague Registry since 2018. Before joining WIPO, Ms. Lähdesmaäki was working in the Finnish Patent and Registration Office for 8 years, the last 5 years of which she worked in the Board of Appeal. She also worked as a judge in the Municipal Court, as well as in the Ministry of Social Affairs in Finland. She holds a Master of Laws degree from the University of Helsinki in Finland. She's also a frequent speaker at conferences and seminars in the field of intellectual property. Pleased to have with us again in Jamaica, virtually this time, Ms. Päivi Lähdesmaäki. Welcome, Päivi.
Thank you, Marcus, and thank you for your welcome. I'm happy to be in Jamaica again, or albeit it's only by virtual means. I was in Jamaica at the beginning of March for a Hague seminar, and I had the pleasure to visit the Devon House courtyard and eat the world's best ice cream there. And next time when I go there, I know that there is this boutique of Teasea, and I will go there to check those beautiful jewels that she was showing us before. And as Adrienne already explained in her presentation, the new design law of Jamaica will come into force, and it allows the accession of Jamaica to the 1999 Act of the Hague Agreement. And what I want to do today is to give you an overall introduction to the Hague system. In my presentation, I first say some general words about the Hague system. Then we will have a look at the geographical expansion of the Hague system, some basic features of the Hague system, and then a little bit how to file an international application, and also what kind of information the World Intellectual Property Organization shares on our website, and some recent developments. Here we can see some recent industrial designs, and as previous speakers already explained, it's the design protection. It relates to the appearance of the product. It doesn't protect any technical features of the product. And here you can see some international applications. I hope that you will hear me, because I saw a message, but I hope that there is no problem in your hearing my presentation. So as you can see, yes, you can see that Mexico is a recent party to the 1999 Act, and Mexico joined the 1999 Act at the beginning of June this year, and many Mexican enterprises have already filed international applications. And in an international application, the applicants may also designate in their home country. Other country in the Caribbean region which is party to the 1999 Act is Belize, which is also often designated, and recently at the beginning of August, Suriname joined the 1999 Act. And the Hague system is basically a practical commercial solution, and it fits for big enterprises, international big enterprises, but as well as for the needs of small and medium-sized enterprises or even individual designers. In one international application, you may get protection in 74 countries and intergovernmental organizations. And those intergovernmental organizations which currently are party to the Hague system are the European Union with its 27 member states and African Intellectual Property Organization with its 17 member states. Altogether, if you designate those intergovernmental organizations and those countries which are also individually party to the 1999 Act, you may get protection up to 91 countries. And currently in the world, last year, it was really like a landmark because more than 1 million designs were registered worldwide. However, most of those design applications are made in China, and they are national applications. When we think about the applications, design applications filed by non-residents, they are about 70% of all international applications filed in the world. And of those 17%, of those more than million design applications, so around 200,000, a little bit more applications were filed last year by non-residents, and more than half of those non-residents filings worldwide were made through the Hague system. And the Hague system is growing because we are very much looking forward, for example, the accession of China, hopefully next year already. And in this slide, you can see up the traditional way of seeking protection for your designs abroad. You have to file different applications in different languages, pay fees in different currencies, and then you get certificates in different languages, and you have to keep a pace. You have to maintain those national registration. They may have different duration of protection, so you have to always keep an eye on them. However, if you use the Hague system, you file one international application. More than 95% of all international applications are filed directly with the International Bureau. We have an intelligent e-Hague interface which helps you through the filing processes. And if there are no irregularities, the international register will register your international application in the international register, send you a registration certificate, publish your international registration in the International Designs Bulletin. And through this publication in the bulletin, all those countries in which seek protection may see this designation of their countries. And let's have a look at the geographical scope of the Hague system. Here we can see the Hague map. And the only red spot in this map is Morocco, because Morocco is the only country which is party to the previous Act, 1960 Act, without being a member state of the European Union or the African Intellectual Property Organization. But previously, we had also Suriname in red, but since Suriname just joined the 1999 Act, its color changed into blue in this map. And Here we have a table of recent accessions to the 1999 Act. We can see Suriname in September, Mexico in June 6, and also this year joined Israel and Samoa. Last year it was Vietnam, Belize, and Canada joined already 2 years ago, as well as United Kingdom. What we are really looking forward next year, in addition to the Jamaica's accession, of course, is the accession of China. And a new patent law of China has now been approved by the National People's Committee by China, and the new patent law in China will come into force on June 1st, 2021, and it is expected that China will accede to the 1999 Act also next year. We are in very frequent, I would say very intensive negotiations with the China National Intellectual Property Administration in this respect. And in this Caribbean region, in addition to the Jamaica, we are very much waiting for the accession of Trinidad and Tobago, also St. Vincent and Grenadines, and as well St. Kitts and Nevis, with whom we have been in a recent contact concerning their declarations, their accession proceedings. And last but not least, I would like to mention Brazil. And we recently started discussions with Brazil's accession, and hopefully it will happen next year. And the last year, under the Hague system, almost 6,000 applications were filed. And since one international application may contain up to 100 designs, the number of designs contained in those almost 6,000 applications were a little bit short of 22,000 designs. And this year, despite the COVID-19 pandemic, we are reaching the same figures as we did last year. Currently, we are a little bit lower than in 2019, but we expect that this gap will be shortened by the end of this year. And I already mentioned that Mexico joined the 1999 Act in June this year, and by the end of October, Mexico was already designated in 110 international registrations. And here we have some statistics about who is using the Hague system. And we have in this left-hand side table, we have the biggest users. And we can see that when we see the biggest applicants, there are 4 Korean companies: LG Electronics, Samsung Electronics, Hyundai Motor Company, and Kia Motors Corporation. And there is one big US company, the Procter & Gamble. And then, of course, there are German company, Volkswagen, Dutch company, Philips also. And you may wonder why in that list there are also 2 Chinese companies, although I just explained that China is not yet party to the Hague system. It is because those are big international businesses, big international enterprises, and they have commercial establishments, for example, in Europe or in the United States, for example, and based on that connection, those companies are allowed to use the Hague system. The most designated contracting party for years have been European Union, followed by its neighboring countries like Switzerland, United Kingdom, Turkey, Norway. And also, of course, in that list we can see big states like United States, Japan, Russian Federation, and Canada also. Republic of Korea is just outside this list. And most applications under the Hague system come from Germany. And the second in the list are the applicants from the United States, followed by Switzerland. And then I will go to my next slide, and we will have a look at who can use the Hague system. The Hague system is a closed system, and you have to have a connection with the member of the Hague Union to be able to file an international application. This connection with the member states or member organization could be nationality, domicile, real and effective industrial or commercial establishment, or habitual residence in the territory of that contracting party. And the Hague system is very simple concept. You file one international application and you get one single international registration in which you can designate one or more contracting parties. And what you get is a bundle of rights. If there are no refusal by any of those designated contracting parties, the resulting international registration has the effect of a grant of protection in each of the designated contracting party according to the laws. Yeah, I would like to stress that the Hague system is a procedural arrangement. Issues such as the conditions for protection or the refusal procedure or the rights which result from protection, they are governed by the law of each contracting party. And as an example, for example, under some jurisdictions, the protection of the industrial design only extends to the similar kind of products, maybe in the same Locarno class, for example. But for example, under the European Union legislation, the design protection covers all the products. So it is possible that the design for a soap dispenser would be considered similar to a coffee machine, and on that ground, the novelty for the soap dispenser is refused because its design is similar to the design of the coffee machine. And also the refusal procedure, for example, if the office has like a opposition period, all those are up to the national laws and practices. So an international applications may be filed in 3 languages, either English, French, or Spanish. And usually it is filed directly with the International Bureau using our intelligent eHague interface. And as I already mentioned, an international application may contain up to 100 designs, but all those designs, they have to belong to the same class of the international classification, Locarno classification. And you only pay one set of fees in Swiss francs, and it's very much recommended that those fees are paid directly to the International Bureau so as to avoid any problems in converting the money to currency, to another currency. And what happens when you have filed an international application? The role of the International Bureau is that our examiners, they will carry out a formal examination of the international application. They will check that the product indications are clear and also that the design corresponds to the product indication. And also they will check the quality of the reproductions and also the views of the design so as to understand what the design really is. In addition, the International Bureau will check the fees are paid correctly. And some countries, for example, United States, requires the oath by the designer. This is also mandatory content that our examiners make sure that it is there in the international application. And if everything is correct, the international application is recorded in the international register, and our examiners, they will send the registration certificate to the holder. And then takes place the publication in the International Designs Bulletin. And this publication takes place on the WIPO website, and it is the only communication to the designated offices of the international registration. The International Bureau does not send any individual notifications to the offices, but all the offices have to go on each Friday when a new edition of the bulletin is published to the WIPO website and check whether their country is designated. And from the publication date of the international registration starts then the task of the national offices, namely they have the 6-month refusal period unless they have made a declaration of a 12-month refusal period. And I also want to mention that if during its formal examination the International Bureau finds any irregularities, it will send an irregularity letter to the applicant, and the applicant then has 3-month time limit to reply to this irregularity. And at this stage, at the time of publication of the international registration in the bulletin, the international registration has exactly the same effect as a regularly filed national application. And this is the task of the designated contracting party. When it finds an international registration in the bulletin designating their country, they have to make the same examination on the same substantive grounds as they do for national regional filings. And if they find a ground for refusal, it must be communicated within the time limit, which is either 6 months or 12 months. And the effect of the refusal is limited only to the territory of the member which has refused it. So it might be possible, for example, that an international registration is refused in Jamaica, but it is in force, for example, in Mexico. And if there are no refusal issued by the office within the refusal period, the international registration has the same effect as a domestic design registration. So basically what the holder of the international registration has is the bundle of independent national or regional rights. And last but not least, I would like to mention the advantages of central management. Namely, the real beauty of the Hague system is that any subsequent change or renewal, it is filed directly with the International Bureau. So if you have requested protection, for example, in the United States, Mexico, and European Union, you don't have to go to those offices to request for renewal, but you send one request to the International Bureau, and you don't even have to send a request. You have to just pay the renewal fees in respect of those countries, and then International Bureau will take care of the rest and record the renewal and publish it in the International Designs Bulletin. And the duration of an international registration is 5 years, and it must be renewable at least twice. But if the country's law provides for a longer period, the international registration may be renewed in respect of that country for a longer period. For example, under the European Union legislation, the duration of protection is 25 years, and under the Japanese legislation is 20 years. And let's have a look from the in practice, how do I file an international application? So on our website, you may find this e-Hague, and we also have a lot of information, and it's good to read the e-Hague tutorial before filing an international application. And we also have a demo version on our website. And when it comes to the payment, we accept several types of payments. You may pay by credit card, debit card, PayPal, or bank transfer, and you may even open a current account with WIPO. And as you can see on the screen, there is one page design for this international application through e-Hague, so you can see all the features, all the elements that you have to indicate in your international application at one time, simultaneously, all of them. And in the e-Hague itself, you can create, of course, a new application, and you can even see those applications that you have previously filed with the International Bureau. And you don't have to always create the new application. You can file a new application from the draft that you have already saved. And then you can also see all the communications from the International Bureau, for example, irregularity letter. And you can also see the tutorial there. And on the top navigation bar, you can see you can ask for support if you have a problem. You can change the language and see your account settings. And fee calculator is included in the e-Hague, and when you choose those countries in the list of countries which is integrated in the e-Hague, it will calculate automatically your fees. And once you are ready and you have sent your international application to the International Bureau, you may print this acknowledgement of receipt. And what kind of information do we share on our WIPO website? As I already mentioned, we publish International Designs Bulletin every Friday, and I picked up this publication which was published in October this year, because this is a Turkish applicant who seeks protection for this nebulizer, which is actually the description of the design is that design is a drug delivery device used to administer medication in the form of a mist inhaled into the lungs. And this international registration designates 44 countries plus European Union and OAPI. So in total, by filing this application, the applicant holder, virus guard, gets protection for his design in 88 countries, and he pays for those 88 countries the amount of 6,248 francs, which I believe is something like less than $1 million Jamaican dollars. Maybe I made a bad conversion, but I believe it's about that amount. So here we can see those countries. And we also have Hague Express database. In that database, you may see all those international registrations which have been published, and you can make different kind of searches in this database. And we also have global design database, which contains, in addition to the international registrations, also national collections of many countries. And then we have Hague member profiles database. You can find in this database information about Hague members in which you may wish to protect your design. You can see their declarations made by the contracting parties. You may find a user guide and Hague system news, and then you can decide in which members you are interested and what type of information are you looking for. And last but not least, I would like to refer to the guidance on reproductions, because the protection of a design is determined by the appearance of the product. So it is very important how you disclose your design. And in this guidance, we have collected in cooperation with some user organizations and some examining offices which are party to the Hague system, instructions on reproductions. So that it's very much recommended that before you file your international application, you have a look about what is a proper disclosure of an industrial design, because those problems can easily be avoided. If you are, it's not difficult, but you have to be careful. For example, you have to have a sufficient number of views, and you have to indicate, for example, if it's a three-dimensional product, that whether there are any contours or of surfaces, and also sometimes if you use different techniques like drawings or photographs, they might cause to a difference between the views. So it's very much recommended to use either photographs or graphical drawings, not to mix them. And let's have a look some recent developments. And 1 year ago, WIPO portal was introduced on our website, and it is foreseen that all WIPO's services via internet will be collected under this WIPO IP portal. And to be able to use this WIPO IP portal, you have to create a WIPO account. And in this WIPO IP portal, you may navigate easily. You only enroll in once, log in once, and then you can even go to the eHague, which is also available through this IP portal, and you can file a Madrid internet. You can see your applications filed under the Madrid system, and you can also file a PCT application, and you can navigate between different fields easily. And in your IP portfolio, you can see all your design, trademark, or patent registrations, and you can also pay fees there. And so there is many services under this portal. And I would like to also mention this WIPO service, WIPO Digital Access Service, which is an electronic system for exchange of priority documents. This WIPO has already for some years existed for patents. A new feature is that it is extended for industrial designs, and currently it provides exchange of priority documents between 17 countries, 17 offices, and those offices, they represent more than 90% of all industrial design applications in the world. So no need to send paper applications, but if Jamaica will be party to the WIPO DAS, it is possible that if you file an international application and you file a priority from a local application in Jamaica, and you, for example, designate United States, which requires original priority documents, you may only indicate the DAS code in the international application, no paper filings. But of course, what is even more recommended is that you have the international application as your first filing, and in that first filing, you also designate your home country, Jamaica. And if you still have any questions, and I'm sure that you still have, you can contact us through the Contact Hague form, which is available on our website. And you can even submit a document to us through this form. And this is like a compilation of our different services, and you can see that you can reach us through your mobile device, through your computer, or through your laptop or iPad. And so please stay tuned, and I'm very much looking forward to the accession of Jamaica to the 1999 Act, and I hope that it will happen very, very soon.
Thank you so much, Päivi. Thank you so much for your detail on the WIPO Hague Agreement. And of course, Jamaica moving very swiftly to accede to that, to benefit our local designers. So thanks for that detail. And of course, the slide will be available for persons to be able to peruse and review in their own time. Thanks again for that. All right, so we have the floor open now for questions and answers of all our panelists. You can ask questions of Ms. Adrienne Thompson. Ms. Teasea Bennett had to leave actually to tend to her thriving business. So she said she would rejoin us. I haven't seen her yet come back, but if you have any questions for her, you can also as well ask it through her email, or go and check her at her shop, even better. Or questions for Dr. Marsha Cadogan or Ms. Lähdesmaäki. So please either type or you can unmute and ask your question as well, right? So no unmute and ask it. Just type a question permitted. All right, so I see a question from Mr. Young. Can you clarify non-commercial based on the learning example is used in a deck or proposal for a project which will ultimately bring commercial benefit considered as commercial use? So I was going to ask Ms. Thompson to address that question from Mr. Young.
Okay, so the section of the law that speaks to non-commercial use says that the right in a registered design is not infringed by an act which is done privately and for purposes which are not commercial. So in this example, if you're using it in a deck or in a proposal, you're not meeting the private bar, and chances are if you're using it in a pitch, it's probably going to ultimately be for commercial purposes. So chances are this would not qualify as an exception, and it would probably be infringement.
Okay, thank you, Ms. Thompson. Right. So again, the floor is now open. We've had quite a bit of information here this morning presented to share with you. So if you have any questions, you can now feel free to ask them, our presenters. As you would have heard from Ms. Lähdesmaäki, Jamaica has been on a path towards the Hague Agreement for some time. And so, we actually should have been already a signatory since this year, but due to the pandemic, we kind of set back that agenda somewhat. So we're still hoping that we would be able to have that completed and to sign up and sign on by the end of the financial year, which is up to March 31st, 2021. That's our current timeline for that. Of course, the new law we are seeking to coincide with that treaty accession. So the new law we hope to also have in place around the same time, which will of course have a new designs framework nationally, new fees, new forms, etc. As with the new law for patents, the fees will also be going up for designs as well. So persons who have their designs they want to register locally with us, now is the time to do so before the new law and the new fees come into play. So we're open, of course, to receive your applications and to walk you through the process. That you can have your design protected and registered there at JIPO under the current framework before the new law comes into play. Of course, once we've signed on the Hague, you will then be able to have your design registered in several countries overseas through one process here through JIPO, or JIPO's guidance, and through WIPO. And so that will also allow you to be able to grow and expand your market to the globe, really, to all the countries that you like to, have your designs marketed, right? I see a question on the chat from Ms. Fairclough asking whether the email addresses for the presenters are available. So I did hear them sharing it earlier. I don't know. We can of course share it if they consent to share it. We will certainly do that. Of course, for us at JIPO, we are always available through phone or email or WhatsApp, social media, JIPO Online, or on YouTube, JIPO channel. For our other presenters, I would certainly ask if we can share their email contacts, and if we can, we would certainly do so. The question on legal issues to do with Jamaica, right? So I don't know if we can have that done. I would certainly, as I say, I'll let you know, or they can do so now if they wish to, while we are in the presentation.
So Dr. Koff, it's okay. You can share my email address.
Okay, but maybe you can do so right now then, since you're on here. We're not hearing you though, Marsha. We didn't hear you.
Yeah, sorry, I was muted. Marsha, MARSHA at Marsha Cadogan, CADOGANIP.com.
Thank you. I see a question asked about whether JIPO is on WhatsApp. We are currently putting that in place, actually. Should have been already too. So that will probably be in place in a few weeks. We will have that WhatsApp up and running, and we'll also make it available to you as well for us to be contacted easily. Right? Right now we are taking applications remotely, so you could email us your applications for registration. You can pay into the account wherever you are in Jamaica or overseas. Of course, if you're filing from overseas, you should get a local lawyer to file through. If you're filing locally, you can file directly with the office. And you would need to come into the office, just file as a scan and email, pay remotely, proof of receipt, and we can process your documents remotely. I see a question. Yes, you were asked to repeat, Marsha, your email address, please. Or maybe you can type it. Yes, I see it. You can type it. That may be also the best.
Yeah, thanks. I'm going to type it in.
Okay, great. Sure.
I believe that the best way to contact me is to use this contact Hague form that I showed in my last slides and put my name on it, because then it will be recorded and I will reply it.
On the last slide. Okay, so can you pick up please? And share that.
It was this contact Hague.
Oh, that's our website. I see. Yes. Oh, the
yes,
contact Hague form. Yes.
Yeah, that is the form on our website.
Okay, right. So you can contact Ms. Lähdesmaäki through the contact Hague form that she had shared with her presentation. Of course, we will have the recording of the webinar available for you to review and for you to be able to, in your own time, absorb. So please feel free to contact Ms. Lähdesmaäki if you want more clarity on the Hague Agreement, or us here at JIPO. And you can also contact, of course, Dr. Cadogan as well for any follow-up from her presentation.
It is very easily to be found on our WIPO Hague website. You just go WIPO and then you follow Hague system, and you can see it at the bottom of the page, and you can send me a message.
Okay, thank you, Claire. Caribbean. Yes. So we see several countries in the Caribbean are moving towards Hague right now. As Päivi mentioned, so Trinidad and Tobago, Jamaica, and the Grenadines. We just saw Suriname acceding in September. So generally the region itself is progressing very well with these treaties. And again, bringing access to foreign markets, closer to the local design and IP owners in the Caribbean. I see a question here. Can we apply to Hague via the JIPO website in the near future? So the procedure for applying to Hague actually is one that it can be done via JIPO or via directly. So it wouldn't be via the JIPO website. It would be really via the WIPO site, the Hague interface. If you're doing it electronically, right? If you're doing it through a paper-based system, then you can do it through JIPO. We will seek to facilitate that for you. So you can get it straight through Hague. Of course, we're here to guide you at the process and the procedures, but we will be having all of that available nearer to the time, brochures, information sessions, website updated, etc., with all of the information for you to be properly able to use and benefit from the Hague agreement. Right. Okay. I saw a comment earlier concerning licensing, and so I wanted to ask. Well, I wanted to invite any questions from the audience on licensing. I saw some interest there, some comments, really. So yes, when it comes to licensing, Marsha, what would be your top 3 tips in terms of advice for Jamaican and Caribbean designers how to approach that issue with a foreign licensee or a foreign potential licensee?
Okay, thanks, Dr. Goffe. First, I'd say ensure that you have basic IP knowledge. I see many, especially startups, meaning early stage businesses or businesses in the very initial stages of their development, entering into IP negotiations where they're not armed with basic knowledge about intellectual property. For many of them as well, design rights are fairly new thing to them, not because it's a new law, but because they're not used to it. They're probably used to hearing about copyrights and trademarks. And so you'll find that knowledge about the difference, for example, between a trademark and a design right and a copyright would be essential. So do the basic research, equip yourself with the basic knowledge about intellectual property. This information can be found online. WIPO has great resources as well, and I'm sure the Jamaica IP office has that information. They're actually free information out there, and in that case, you're saving yourself at the initial stages, at least, from even using an IP lawyer. Get the information, be aware. Knowledge is power, right? The second thing is, there may be so many different types of products out there that you can design, but design strategically. Ensure that to ensure that it is something that is in demand, not just by consumers, but also by that venture capitalist or that person who would be willing to go into a royalty deal with you. In terms of the substantive portions of the agreement, know your market. Your Chinese market is going to be different from your Canadian market in terms of the terminologies used in the licensing agreement, in terms of the grace period being offered, and even in terms of the level of examination that goes into the granting of the design. That's important as well. I'm probably going over 3, but I think all these are kind of like interrelated with each other. Monitor the right, monitor your design right. Even though you license the design, it doesn't mean that you've waived unless you've done so by the contract. But even so, that is not right. I mean, it's not going to benefit you in the end. You need to monitor how the licensee or licensees are using the design. And this could go from the type of articles that they're using the design on to whether or not they're granting rights to use the design to sub-licensees where that is not a part of the agreement. That's essential as well. Another thing is, design rights don't last forever. It could be 10 years or 15 years. I think in Monaco it's 50, which is interesting. But so what happens after your design right is up? So, you're getting a good royalty from the deal, say it's working out, but it's approaching the end of the agreement. What do you do? Especially if the design is the only IP. It wouldn't be the only, because you need to trademark, the name that you're using or so on. But what if it's the most lucrative part of your IP investment? What do you do from there? So strategically, I would say, think about, this is going back to Dr. Goff's question, can you, depending on the law of the jurisdiction, can you turn that design, depending on what it is being used for, into a trademark? So this is possible in some jurisdictions, especially if it's a three-dimensional design where, you can incorporate segments of it as a part of a trademark and decide whether or not you as the licensor want the licensee to have any interest in that as well. So these are just issues at the forefront. Another point which is very essential: know how the jurisdiction that your license, you could be dealing with Canada and the US. In Canada, as I said before, if the industrial design mark is not on the product, it limits the remedy that's open to you if there is an infringement. In the US, you kind of need to have the mark there to claim anything, because it's under their patent rule. So I'm not sure how it works in Jamaica. Ensure that your licensee are versed into the types of issues that can impact the remedy that we would receive if your right is infringed. These are what I can think of at the outset.
Okay. Thanks for that comprehensive answer. Good tips, good advice for persons who are seeking to use that strategy of licensing. To be aware, of course, of the pitfall, but also of the opportunities that they present. Okay, I see a question which I'm going to pose to Ms. Thompson in the chat. The question is, as it relates to traditional knowledge and traditional cultural expressions, how would one go about obtaining consent? Who would grant consent, for example, of the Rastafarian community? So that's something that we have in JIPO as a relatively novel approach to TK protection. And so I'd like Ms. Thompson to share on how we currently deal with that sort of situation.
So we actually have this practice at JIPO also for trademarks, and if there's a trademark that contains TK or TCE, we require consent or authorization. And so what people do is that they go to one of several of the recognized houses of Rastafari. They have various institutions, and they can obtain permission from one of these institutions and submit the letter. That should be sufficient.
Right. So I hope that answers the question. Of course, we're here for guidance as well if you wish to get further understanding of that, or to be able to get some further information. Please, you can always email us or contact us. We can guide you on that. And yes, the new law, as Mr. mentioned, will also have that as a part of it. So that's something that we will be going forward with. Right? And also including the national symbols and emblems. Similarly, would need certain consent, or the use of other copyright or trademark material, or anybody's image rights, in the design, or the country name of Jamaica or any other country. These are all things that we have sought to include in our new designs law to ensure that we protect things that are intrinsically due to be protected in our national framework, which may not be captured in the international rules and designs. So thanks for that question. I hope it was clear, the answer. All right, we're gonna wrap up. I was gonna ask Päivi to explain briefly for us. Päivi, the designs framework on the Hague speaks of having more than one design in the same application, right? And that's something that is new to us into the national framework. It's different. So just to clarify, how does that in practice work? You know, and what are the rules and procedures which would be applicable in that instance?
Thank you, Marcus, for your question. So it related that there are many designs in one international registration, and I didn't get what was the question. Was it about infringement or was it about refusal or?
Well, just how it works. You know, what are the rules that would be applicable? You know, how similar or different can those designs be? Would that have to be in the same class or not? How does that affect the price and those kind of things?
Okay, so as I said, in one international application, you may have up to 100 designs, and under the Hague system, there is no requirement that those designs should be similar to each other's. The only requirement is that they are in the same class and they can be very different from each other's, and they can relate to different types of products as far as they belong to the same class under the Locarno classification. However, as I'm sure you know, many countries have this unity of design requirement. For example, under the United States law, they only accept in national applications designs who have the same substance, who are basically variations of the same design. And however, under the Hague system, you can have as many designs as you wish in an international application, up to 100, of course, and designate United States. And what, for example, USPTO does is that it refuses on the ground of lack of unity, and for those designs which do not confirm with the requirement of unity of design, which are not patentably indistinct, you have to file divisional applications directly with the USPTO. But however, I would like to stress that this is only certain countries who have this unity of design requirement, and most countries like European countries, they don't have this kind of requirement of unity of design, and they never refuse on that ground. The grounds for refusal, for example, could be lack of that it's against public morality, or Article 6 there, emblems of states, flag of states, and some offices do also prior art examination, maybe following opposition. But actually, under the Hague system, there is no restrictions as to similarity, as to the product names at the time of filing. And when it comes to those refusals, there are issued by the offices, there are different practices. For example, if you think about Korean office, which is also an examining office, they issue refusals. If you have 5 designs, the same refusal relates to all those designs. So that design 1, it's lack of novelty. Design 2, it's similar to other design, or some, so that they list all those designs and the refusal grounds separately. But for example, Japanese office, they issue refusals separately for each design. They don't refuse on the ground that those designs are not same, are not similar to each others, or that there are more than one design in one international application, but they might refuse the industrial design on the ground of lack of novelty, or that the disclosure of the design is not clear according to their standards, and Japanese office issues refusals per one design. And because the examination at the Japanese office is very thorough, and the examiners, they are really specialists concerning certain products, and so the examination um, may for some products be much quicker than in respect of other products. So there will be several refusals by Japanese office, but all those refusals have to be sent within the refusal period, which is either 6 or 12 months, and that's how basically this happens at the office level.
Okay. Okay. All right. Thanks for that detail. Okay. I see a question here, which probably will be our last question. As it relates to the case law, Puma and Forever 21 mentioned by Dr. Cadogan were both designed registered at the registry.
No, just the Puma design. And that's why that's why Forever 21 could say, you know, it's been around forever. Well, not forever, but since the 19th century, you know, and get it invalidated.
Right, right. So Puma was the claimant, Forever 21 was the defendant in that case.
Yeah, yeah.
Right, right, right. Very interesting, very interesting. All right. So thanks again then to our distinguished panel of speakers this morning into afternoon. I want to thank Ms. Adrienne Thompson, our trademark designs and GIS manager here at JIPO. I want to thank Ms. Teasea Bennett, who is our featured designer in this webinar, co-owner of Reve Jewellery at Devon House. You check her out, check them out. I want to thank Dr. Marsha Cadogan of Canaan British Consulting out of Canada, and Ms. Päivi Lähdesmaäki from the Hague Registry at WIPO for their insights and for sharing their time and knowledge with us in this important webinar on the new designs law and the Hague Agreement. So thanks again for your time, for the audience, for your questions. Thanks for your participation and for staying with us. Look forward to having you the next time as it relates to our next webinar in the series. We'll be having actually a webinar jointly with WIPO on the 1st of December, as well as on the 8th and the 14th of December. We'll be doing webinars with WIPO, regional webinar focusing on enhancing the capacity of SME support institutions to be able to better support the SME sector where IP is concerned in the Caribbean. So we'll be having those webinars on the 1st of December, 8th and 14th at 10 a.m. to 12 noon. We will be sending out those links as well. Is that ready? Yes, that's it. Yeah. And we will be also, of course, inviting persons from across the region to stay with us for those interested in webinars focused on enlarging and growing the SME sector. You should see a poll on your screen that has been started, which is now available. Please answer the question, just I think 4 questions very briefly, as we seek to get your views and to ensure we can take into account your feedback as we try to improve our information sharing with you, the wider public, where IP is concerned. So just a very short poll, just take a few minutes, actually a few seconds to answer. That will also help us to improve our service. All right. Anything else to mention? Oh, right. Okay. So the poll has been launched. That's the first question there. Persons maybe staying with us or having to go, but please take the time to completed. You have to close one before you open the other one. Okay. All right. So we've launched the second one there. Again, you can contact us at JIPO. Email info at jipo.gov.jm. info@jipo.gov.jm for general queries. You can also call us at 876-946-9216, 946-0789 or 876-946-1300. Again, we're also accessible through our social media pages, JIPO Online. We're on Facebook, on Instagram. We're also on YouTube at JIPO channel, the JIPO channel, Twitter, JIPO Online, LinkedIn. So please, many ways to reach out to us. And as I said before, we will be also having our WhatsApp very soon activated. Okay, so this is the fourth question now. It's the third question. Last question here we have on the poll for you. Thank you again for staying with us. I look forward to having you on future webinars where we get to talk about and explore the different opportunities that exist for you in the IP industries. Thanks again to everyone. Thanks to our presenters. Enjoy the rest of your afternoon and your evening. Päivi, thanks again for coming from across the world and for coming from Canada, Marsha. And we will be in touch and stay glued to your JIPO channel for further JIPO webinars. Okay, so we sign off from JIPO Studios.
Thank you.
Thanks. Goodbye.